Hi, I'm Debbie Moraes. Once again, welcome to Legal Matters, the program that's been designed to address the critical, sometimes contentious issues that are facing businesses and consumers today. Legal information, practical solutions, and straight talk about a wide variety of topics that affect your home and work life. Today, copyright infringement, trademarks. Think it might not affect you? Think again. So whether you own a business or you work daily with computers or even minimally use technology, and specifically the internet, and who doesn't, there are many hot topics in the technology world today that could get you in a lot of hot water. So what is intellectual property, and what are these terms about, and how do you get in trouble? How do you keep from getting in trouble? So let's ask our lawyers. Once again, we have with us from Bazar, Grasso law firm in East Providence. To my right, Jackie Grasso, and to her right, David Bazar.
Debbie.
Let's get to it. Okay, so first the basics. What's intellectual property? What's copyright? Explain what they are.
Do you want me to go?
Go ahead.
All right, so intellectual property is a term that covers all of those things you mentioned: copyright, trademark, patent. They all actually cover different things, but think of it as a personal property item would be something like this cup. It's something you can feel, touch, hold. Intellectual property is the value of owning an idea or in the terms of, in case of patent law, a process for doing something, or in terms of trademark, the right to use a different name or symbol or type of thing of that nature. So intellectual property consists of those three different issues.
And how does one determine how to protect those things so that if someone else uses them, they actually could be in trouble?
They're actually all different.
Well, it's a very specialized area of law, so I say this telling our viewers that if you do have an idea or you do have a product with a patent, you need to find a lawyer who specializes specifically in trademark and patent law. So how do you protect it? The United States has a patent office. United States Patent Office. So you can go on a website and they tell you how to register your trademark or your copyright, the different laws for copyright versus trademark, and then you have to know that certain things can last forever, like an idea can last forever as long as it's utilized, whereas you have to register other copyrights every 10 years.
Exactly, and here's what happens. It's actually interesting that back in the formation of the Constitution of the United States, the trademark office was one of the first things already established. We have agency law now with thousands of agencies that didn't exist at that time. But the Postmaster General and the Patent Office were very early creations of our agency system. So in any event, you take a look at the three different areas we talked about. Patent law, which is you have an idea for a process of how something might work. Well, that's a whole special process that goes through, as Jackie was saying, to register the patent and to have someone who understands how that works. You usually would have an attorney. The attorney probably would have some engineering background to understand it exactly what you're doing. But in any event, you go through that process, the patent is issued, and then it's good for a certain number of years that can be renewed. That's the time frame Jackie was talking about. Copyright really is protecting somebody's idea for something. Oftentimes we see it in music. Somebody comes up with the idea for a song, they copyright the song, or a book, or a title, or something.
So it incorporates artistic elements,
artistic
basically.
elements, and you're protecting the idea of those artistic elements. Trademark really is trademarking a name or something associated with a good or a service. Coca-Cola, Kleenex, those are some things that come to mind for me when you say trademark.
I suppose I could quickly add that if it comes to someone who's creating something or has a new invention, the local, the statewide, small business centers, small business administrations, and SBDCs usually can help guide someone through the process if they think they want to go through the process of doing it themselves and checking online. It is a little bit tedious, but it's not impossible, and that's always a very good start. But when you mentioned, David, music or art or poems, I think probably most recently in the news people will hear about the fact that if it's online, everyone owns it. I guess not quite so. I believe it was Napster that first had the issue about music blowing up. So it's on the internet, it's available. Why can't I download it, share it, put it on every technology that I could possibly think of, plus my grandmother's? Why should I be in trouble? it's out there.
Again, if you look at music, if you take someone's music without their permission and you download it to your iPad or actually iPod nowadays.
iPad.
Well,
iPhone.
basically what you're doing is you're denying the creator of that music the right to receive compensation. So in the business we call it a royalty. So you just can't download something without permission, and I believe that's what happened with Napster. Is a student from Boston University, I think, or maybe it was Harvard,
Yeah,
I forget where it was. He was downloading hundreds and hundreds of songs. I think he lived in Rhode Island,
did.
as a matter of fact.
Right.
And he got sued in federal district court.
Right. And I'm not sure it was the Napster program he was using
He was
to do it,
downloading,
but he was downloading music.
and he wasn't paying for it, and he was sharing it. And ultimately, litigation ensued. It did last a while, and he was ordered to pay fines.
So when we talk about copyright, the Internet has an impact on almost everything we do in these areas, especially trademark and copyright. But let's just go with the copyright, for example. If you own a business like a restaurant or a bar or a lounge with music in it, you may have some issues where they have these unions that protect the musicians, and you may have to pay dues or
fees.
Exactly.
For music.
So
Music.
yeah, and I've actually heard of cases where they want money for live music, they want money for TVs, they want money for radio or CDs or whatever you're paying. So if you buy a CD and you want to play it in your restaurant or your lounge or whatever, there still may be money owed to these, or at least these unions think there's money owed to them for the privilege of doing that.
We had a lawyer in Rhode Island who used Mickey Mouse as his logo.
Yes.
And eventually that came to fruition, and I think Disney filed something. He had to get permission, or he had to change the image.
Right.
This is like the Barney thing, too.
A little bit to get it done.
Yeah.
Exactly.
Yeah.
He would first get a cease and desist order.
Correct.
And if he chose not to,
Then he'd be paying some
take
damages.
the gloves off.
Right.
Whether
Exactly.
Mickey Mouse's or otherwise.
Who wants
So,
to fight a big company like that?
I'll give you an example of a trademark where I had a client who was involved with an issue. He had a little business, very small, where he raised and bred pugs. And so he advertised himself on the Internet as Pugs R Us. Well, did he hear from Toys R Us eventually?
did,
Yes,
yeah.
he did. And they wanted him to stop. And so their claim was, well, Pugs R Us might actually be okay if you turn the R around, but Toys R Us has the R backwards, and they did not want him using the R facing the wrong way.
So would it be mitigated by him putting Pugs R with the correct R, us, and they're fine with it?
I think they wanted him to use the word.
A-R-E.
O-R, O-U-R, R.
Oh.
Oh, A-R-E, you're right.
Yeah,
A-R-E,
okay.
right.
Yeah.
Well, he could have used the other one because he
that's-
couldn't.
yeah,
But the
yeah.
real long and short was the crux of that matter was the way the R was facing. That was their best argument because people identified that backwards R with Toys R Us. And so I don't think they really wanted to sue this guy raising dogs in his basement, but they did want to get some difference between how he was using it and their R backwards. And so A-R-E, O-U-R, whatever he
Either
did,
way,
it would have been fine with them.
Anything but backwards R. So what you're addressing is maybe patent law, in some cases trademark law. How does the idea of tort law come into play with such possible infringements?
Well, it's not, I wouldn't think it's really tort law. It's really if you're saying someone's infringing on
I guess that the fact that it overlaps with several other areas of law, and I could understand copyright
Privacy.
law. Is that what it is? I'm not
Maybe.
sure.
Yeah.
Is that the road you might go down?
misappropriation, I
Correct.
guess you have a property right and you're saying someone's misappropriating it.
Contract.
Or passing off their product for yours.
And that's a tort?
You could call it a tort.
Is it a stretch?
When we define torts as a civil wrong, then I suppose that could fall under the umbrella of civil wrongs. Most people, when they think of torts, think of injuries and that type of thing. And there is an injury, I guess, if someone's property rights are being diluted or infringed upon.
I think we'll talk about that in a larger aspect in a minute. But as you start to address the issues about trademark and copyright, the average homeowner maybe small business owner sits at home and surfs the internet and happens to see an image or a line or something and says, why shouldn't I just drop it on my site? Copy, paste, click, C, Control S, and save. Done. What harm?
Well,
Only harm if you get caught?
Eventually, I assume, especially if you're taking Mickey Mouse from the Disney website and putting it on your on your Facebook page, for instance, people need to understand that a hyperlink or an image that they take from the internet is a property right. For instance, who was the football player there with the girl's image? Somebody took that image, and if they had profited from that image, or just taking her image without her permission, is a violation
of her privacy.
Privacy, yeah.
Right.
Yeah.
And yet her picture is not a copyrighted issue, but the photographer who took that photo could have been an issue, certainly.
On the internet, I think you'll often find people creating websites, and at some point in time may hear from Getty Images or somebody of that nature where they take a photo from the website that may be owned or registered to some other person or company like Getty Images and saying, wait, you can't use that without paying us for it. So you can't
have to get permission.
You have to get permission or pay.
Or
you
pay,
can't necessarily just take some other person's photo or hyperlink or any of that information. Now, there's a difference between doing that, perhaps, and having links from your site to stories or other things where you don't take the entire amount of what's written.
If you are using Facebook and you're a good reader, you might have found an article or possibly something that you thought was worthwhile. The internet is a network of networks, and so you certainly are able to use that and let your Facebook likes, friends, fans, depending on what kind of a page you have, let them know that you're enjoying this and you think that they should be reading it. Of course, to say that it came from the Seattle Sun or the Washington Post or the Providence Journal and give that person credit certainly made sense. But very different right now is the idea that there are larger sites that are commercial in value somewhat, you could argue it, that are taking whole passages of another journalist's work from another paper. Now they're called aggregators. Now we have lawsuits and they're proliferating. And I guess there's great debate about what the possible value or what the possible lawsuits are about. What's fair use? Can you explain what that is? Public domain? What's fair use?
Let's start with this. Let's go to the extremes and see if there's something that works us towards the middle. If somebody writes a story for the Providence Journal, say for example, I think they could clearly claim that it was an infringement of their rights if some other internet group, call it what you want, you say something like the Huffington Post, but not them necessarily, took that entire story and put it in their website. I don't think anyone would argue that they're allowed to do that. They're not.
They do argue that, though.
But the whole story is probably, especially if it's protected under any copyright or anything, they can't just take the whole story. What they could probably do is take a reference to the story with a description of what the story is about or a few words from it or sentences.
Maybe link it back.
And link it back to the Providence Journal website.
So one concern I have is if you do read a particular story on that, any website, a journal website, they give you the ability to share the link. So they'll tell you, share the link, print it, email it. Aren't you just, in effect, doing the same thing?
Not illegal.
Well, they want you to share the link, and I don't think they'd object.
But if I put it on Facebook?
Yeah. Or I don't think they'd object to an aggregator, whoever that might be, sharing their link because it goes back to them, so they get the hit, they get the audience. I think what they would object to is if there was a whole story of what they wrote that doesn't require anyone to go back to them to get the same information.
Apparently, some part of this, while they're talking about those blogging and social media, those aggregators, those who do that for a living, they are allowed to use the headline. They're allowed to use up to 150 words. But as that has still been challenged in court, apparently there is great debate about whether or not that even with that link to its source, might be, in fact, undercutting that newspaper, say it came from a newspaper or a magazine, undercutting that media's subscription base. The aggregators argue, well, it will help you sell papers because people will want to read the rest of the story. Those will say, not necessarily so. All someone might want is 150 words and thank you, and that's enough. And so that debate is about a financial issue. And I guess something, David, Jackie, about fair use has to do with whether or not those aggregators are using it for a commercial purpose. The site itself might not be commercial until they start putting ads on it, which then makes it commercial. Where do you, I mean, it's...
So then they're profiting from it, and now you have, again...
Gray area.
Gray
right.
area, yeah.
And the 150 words, I suppose that the 150-word limit is interesting because what if the story is 300 words? Now you've told half the story. If it's 1,000 words or 3,000 words, it's just a little snippet. So I think a better argument might not be the number of words so much as how you're using it.
But what if they participate in the Associated Press? Doesn't that give them the ability to grab a story from another newspaper as long as they credit the newspaper?
That apparently is being challenged right now.
Area.
They're talking about what hot news misappropriation is, how you're using it in part, and whether or not it actually is undercutting. And considering there's been a backsliding or a reducing of circulation, I guess that has certainly prompted the cause to say we're losing money, we the media who are being part of that aggregated system. It's an interesting thing to see how people will generally go sifting through several sites, put them together, and then are you really claiming it as your own if you're that aggregator? Well, they're claiming that they like the piece. I don't know if they're claiming that they wrote the piece. It's just a very interesting thing. Those of us who might want to show that we liked reading a certain columnist's, journalist's article, beyond saying, I really enjoyed the Providence Journal's recent thus and such or the Boston Globe's, do I have to do anything more with that, or else before I'd get in trouble? Can I just and only say this came from the Providence Journal, excerpts from? Does that clear me?
Are you talking about the individual?
Yes, if I take part of an article and said I got it from the Providence Journal.
I think you need to credit the Providence Journal. I think you also need to credit the journalist as well.
Yeah,
and ask permission?
Well, depending on how you're using it. If it's you as an individual just saying, hey, I saw this story and I like it, and you're putting that on Facebook, you're probably not running afoul of anything. But if you're the aggregator, as you call them, and you're putting up all this information, then you may need permission in advance if you're going beyond just the hyperlink and the...
I think, but you're not putting it to commercial use, so I don't think it would be as... it would be...
Maybe there's no damage.
Yeah.
I guess the government currently says that if something is factual and informational, that should just be liftable. But if it comes attached to somebody's idea or slant on it, then it's changing how it's being used.
It isn't an idea even if it's informational.
I don't know. Hence, because there's no real history of these cases, which I'm sure you all cite when you're dealing with various litigation, there's not really a precedent that's been set. This is definitely new and wild frontier for judges and for you folks too.
Talk about it in terms of a news story. If the Providence Journal writes a story about a fire, for example, does that mean that someone on the radio can't say the Providence Journal reported and then give the information? I think they can. I think they do it all the time.
As long as they attribute it to the author, or
where it came from.
Yeah.
And that certainly could help them to sell papers.
Right.
It's free advertising when you stop and think about it.
And in fact, in many cases, those of us who may not be published with Providence Journal or Wall Street Journal would look forward to having you take what I write and put it on your website because you like it, and then your readers will find that they like what I write. And so that's the idea of what social media was meant to do in many cases without it necessarily causing a commercial problem. But once someone starts putting ads on their site, which I'm currently not doing, I don't know how many others who are small businesses or even the average consumer, whether or not they're likely to get advertising on the site. If they do, then you might take some issue with it. But let's just say for that website that I as one individual might put together for myself, if I go to the Microsoft's clip art, it is clip art, doesn't say that I have to pay for it.
Any part of the program.
Is that part of what I can use?
You are paying for it.
indirectly.
Yeah,
That's
because
right.
you're paying for the software, you're paying for the use. And, you know, when you sign in, it gives you that 22-page agreement, licensing
Right. So
agreement.
you should go directly
Yeah.
to that page that deals
And
with
And
using
read
the
all
equipment.
25
Right.
pages.
I mean, you are paying for it.
I haven't read that section, so I can't tell you whether you can use it or not, but feel free.
How
Yeah.
many people
Probably
have you?
page 21.
It's just like when you go to real estate closing, who reads all those documents, right?
But
The guy who wrote them.
if you saw something that was on the internet and you think that it's clip art in its public domain, if you change it a little bit, does that make you likely to own it? Now, these are examples where the average homeowner might likely say, well, if I just change this, it's new. I've created it. Have they? Have they not?
Not really. It's recognizable back to the original form. You know, just tweaking it a little bit doesn't make it yours necessarily. I mean, perhaps it could. I'd go back to that page 23 or whatever page it is and read what you're allowed to do with it.
I think that's similar to the Mickey Mouse costume, because if you see Disney, you see Mickey Mouse and Disney, it's obviously it's his image, but
Yeah.
you hire these party agencies, party planners, they have Mickey Mouse come in, but it's slightly
Right.
different.
Right. And
So-
then I remember a case
Yeah.
where it was slightly the reverse. I think Walt Disney or Disney Studios or whoever it was used a local diner's image in
Yeah.
something they were doing without the diner's permission.
Correct, yeah, and he had to change the image.
They had to get his permission, I think.
Really?
Yeah.
Would your average confectioner who makes cookies and candies, deciding to put 2 chocolate wafer cookies with cream in the middle and call them
Oreo.
our Oreos, our vanilla pistachio nut dunked Oreos, even they could get in trouble. I don't know that most people start out thinking that they are going to do something that's illegal. It just seems that's what it is. It's like Kleenex. It's a name we all know, and thought that would
Trademark.
easily
Right.
be something that they could use. And to
It's a
your
household name.
It
Yeah.
is,
Yeah.
and
And
they might
sometimes
be able
with
to
a
get
trademark,
away with that.
that household name becomes so much of a household name that other people can actually use it to some degree.
And therefore, there is no lawsuit, right? Or there might be, but
Perhaps.
you're not going to win
Right,
it.
depending on how it's used, correct. I don't think you could sell your tissue as Kleenex, but you could describe it as a Kleenex type of product if Kleenex is so now thought of as tissue.
It was the same thing about Xerox.
Right.
Years ago, it's like, go Xerox,
It was
everybody
a
knew.
brand.
Right.
Now it's a
Copy.
It became a verb.
verb.
Yeah, yeah.
Yes. And to your point about the Monte Teo story earlier and the woman whose photo was lifted, in similar cases, maybe some of our viewers look at Pinterest, which is a popular social media site, in looking at various photos and possibly thinking about collecting part of a photo and part of something else and putting it together to make something of their own. Apparently, Pinterest is now a target of many who want to have lawsuits saying, you should not have accessed that picture, I didn't give permission. And it might have been a photographer who was posting his picture on, or one of the pictures he had taken on site, someone else decides to use
It's
it.
not only that, YouTube.
Yeah.
YouTube. Go
And
ahead.
people
Explain.
take clips from television shows all the time, and they'll put them on YouTube. You know, are you getting permission from the network to do that? I mean, there are millions and millions of clips that you can come from television stations or clips from movies or something like that. Same thing. I think you're going to have an issue there. Yeah.
So how do we responsibly get to use or download and share music, some video? If you didn't take it, does that mean you just plainly should not ever use it and have some fun with it and share with your family and friends?
Well, for instance, the iTunes gives you the ability to share your music. Okay, you have to pay for whatever you download, but you can share it. I'm sure somewhere in that 22-page licensing agreement, it tells you how you can do that. But if
400 friends, Jackie?
well, that's a little different, you know, but you can share the music.
There are
There's a
rules.
limitation, I'm sure.
And that you have different iPads, iPods, iPhones, all those different things that you're allowed to put it on those things as well as the computer you maybe originally downloaded it to. So there are rules that you have to follow, but that's what the whole idea of it was, follow the rules.
Yeah.
And for those who are creative, those who are on the creating side, the innovator side, there seems to be some debate about whether you use the poor man's copyright, namely you take the picture of it, you put it in an envelope, you send it to yourself, it becomes you never open it, it becomes your proof of creation as of thus and such a date, so if someone else comes up with it, you have this as, apparently that does not work.
No.
The trademark, copyright, patent, all are different. So trademark, the use of it can create a property right in it, even if you haven't yet registered it. Now, of course, it's much better to protect yourself by registering it, but what you're protecting is the use of whatever it is you would have trademarked.
I think she's talking about something copyrighted. Like,
yeah, no, copyright, that's what I'm saying. Copyright's different.
Yeah.
Copyright, you have to get the copyright with the seal of approval, so to speak.
And of course, those who might want to protect their creation, their innovation, considering we have a global situation, it's very hard to know that even if you want to do some research, you might likely have created something that someone also in Australia is simultaneously working on. In the U.S., apparently, it's not just who was the first to create, but also who's the first to file for it, who was the first one to put it in paper. So even if it is half-baked, not that I want to say this, but even if you haven't fully brought it to execution or completion, do you advise that someone actually get to a lawyer or get to have it protected and
definitely
on file first?
Yeah. It's not a simple process, and it is a lengthy process as well.
And especially with a patent of a process. I think we had that with the telephone. And whether Alexander Graham Bell created the phone first is a subject of debate. I think there's some story that somebody else actually had it first and just he lost the race to the patent office.
Are there many IP lawyers, intellectual property lawyers in Rhode Island? Is there really much, or Massachusetts, is there much use and much reason to do that, considering there are many creative people, especially in the software industry these days, who are doing things?
I would think you'd find more in the New York City area, in the
but
Boston area. But
we
we do have. There's several, like larger law firms
right.
do have people that trade. You actually have to take a bar exam to be a
for a
patent
specialty?
attorney. Yeah.
Even though there's not supposed to be specialties in
No,
a
to
given...
practice in that area.
To practice in
that
that
at all.
area.
Not in Rhode Island necessarily, but to register with the patent
You have
office.
to take the test.
Yeah, I'm not sure what the rules are with that, but there is a process, I'm sure.
And we didn't really touch on, there's an issue about you applying to federal patent offices. Is there a state set of laws that says you can use this name or this this design symbol, but only in New England because someone else is using it in the Midwest? Do we have to worry about state to state or region to region, or just federal?
Well, no. I mean, you do. Every state has copyright laws.
There's common law that applies to the use of trademarks, common law that applies to the use of different intellectual property rights.
Rhode Island has a statute.
Right.
And well, I came across in my research, the state of Georgia makes it a crime for somebody to use a hyperlink or a domain name without their permission. So yeah, there are state laws as well as federal.
I was interested to find out that even when I had registered the name of my business, that it's certainly okay to use it right here and in certain areas, but there might be, in fact, there are others in the Midwest that have very similar names that might mean that I have to change. Same thing with a domain.
A name can be geographical and limited geographically.
And that's about incorporation more than it is copyright, though.
Although it's trade name, and using that name in certain areas may be allowed here, but not in California if somebody's already using it there.
We covered an awful lot of information. Once again, we'd like to thank Jackie and David from Bazar, Grasso law firm in East Providence. Thank you for tuning in. Our discussion of legal matters continues.